Good morning. Thank you for coming out this morning. My name is Christine Tatro. I am a member of the board here at Jericho, and I'm also a special education attorney. And I am also the sibling of a developmentally disabled sister. She was diagnosed in 1961 with a severe intellectual and developmental disability. And as you may know, 1961 was about 13 years before the first law went into effect. So my parents were among the pioneers of getting special education services for their child. Actually, we were among the first members of Jericho when Father Wagner and Sister Joan started Jericho. And I also have experience as a parent and a grandparent of young people with special education needs. So I've been there, done that, I guess you could say. So the topic for today is discipline and suspension in Massachusetts. And this is specific to Massachusetts. I'm going to talk about our discipline laws. Not all of this, in fact, most of it is not specific, or you don't have to have special needs to be affected by this, because the law applies to all students, and then the IDEA provides some additional protections for children with disabilities. And so we'll talk about that as well. But this kind of information can be helpful to anyone who's facing discipline or suspension. So I'm sure you've probably heard the myth or the complaint that students with IEPs can't be suspended or expelled. Some parents will say, my child's in a class with this kid with disabilities and the kid disturbs the class and there's, quote, nothing they can do about it, which is not true. The thing they can do about it is support that child better. But it's also a myth that a student with an IEP can't be suspended or expelled. The fact is that students with IEPs do have certain protections under state and federal laws, but they can be suspended or expelled in certain circumstances. So first I want to talk about the sources of the law in regard to discipline. And you don't need to absorb all of this, but just know that there are reasons that practices exist. And they are based in the law. If you hear a school, if you're dealing with the school and they say, well, that's our policy, you want to ask them, what's that policy based in? And can I see a copy of that policy? That policy is 9 times out of 10 not in writing, and it's the policy of the individual that you're talking to. But these are the actual sources of the law. First of all, obviously, the United States Constitution. Everybody's entitled to due process under the 14th Amendment, and that does apply to students within certain parameters. Now, under the federal law, the IDEA is the main source of the protections for children with special education needs. But also sometimes the Section 504 gives protections, or you can take action under that, as well as the Americans with Disabilities Act. Both of those prevent discrimination against students with disabilities. And then the Massachusetts state law with regard to discipline is broken into 3 sections, and I am going to go into detail about those because it matters which section the student is charged with. It matters which section the school is taking action under. And and finally, the student handbook and code of conduct. That should be what the school is referring to when they say our policy. And some of that is dictated by the state law. The state law says the handbook must contain certain things, certain information about rights. So that's where everything comes from that we're going to talk about today. And there's the Bureau of Special Education Appeals, which is the administrative law branch of the Commonwealth of Massachusetts. They're kind of the final arbiter of any disputes when it comes to special education. And they issue, just like any trial, they will issue rulings. And I just cited one particular case, and it says that Massachusetts defers to the IDEA, the federal law, in cases involving special education students, and therefore the due process protections under the IDEA trump any other state issues addressing discipline. So if there's something that conflicts, the IDEA rules. So here's the breakdown. As I was telling you, there are 3 different sections in Massachusetts law. Under Chapter 71, again, you don't have to memorize this, but just know there are 3 parts. Section 34H, that refers to discipline for possession of drugs on the school campus, possession of weapons on the school campus, or assault on a school staff, okay? So that's obviously the most serious in terms of the school. And in terms of the parameters of that, it also includes any activities that may not be on the school ground but are related to school. So for instance, on a field trip, you're not on school grounds, but it's a school activity. A sporting event that might be at the rival school, not at your own school, but you get involved in a fight or you get found with drugs, or that would be considered under 34H. Okay, so that's the most important one. The location of the event I just talked about. Also on school transportation. Some school districts don't actually own their transportation. It's a different company, but it's still considered to be the school's responsibility. And the permissible consequences are up to expulsion. It's one of the hardest ones to overcome. And then the second one is 34H and a half, because that's how we do things in Massachusetts. When we amend statutes, we don't like renumber everything. We just tack on and a half or 3/4, and that's what we do here. And this is this section addresses felonies. And so when a student is charged with a felony, either in adult court or as a delinquency matter in juvenile court, they can't, and this can be in or out of school, it doesn't matter. It can be in or out of school. They can be suspended. Doesn't have to be. The statute says may. They can be suspended for the length of time, a period determined appropriate by the principal or the headmaster. And this is the important thing, and this is what I always am trying to say to parents, and when we're advocating with the superintendent or the principal, if the principal determines that the student's continued presence in the school would have a substantial detrimental effect on the general welfare of the school. And it's very much up to the principal's discretion. So, as one example, there was a horrific car crash in this area back in the fall. Maybe it was even last year now. And a woman was killed, and it was very notorious. It was all over the news and so on and so forth. The person who was arrested for it was a student at a local high school. And of course, everyone assumed that he was in school the day after he was arraigned. They did not suspend him. I don't know what other stuff was going on, because obviously that's all confidential. But one thing you can know, if they're in school, they were not suspended. And this kid was allowed to stay in school. More typically, I think a principal would make this determination if it was a felony and it might have impacted other students in the school. You know, like if there was a fight that had nothing to do with school, if there were other students. So it is discretionary, but again, that can happen regardless of whether the school was involved at all. And the other thing, oops, let me go back to this. And then the next step, though, is if the person is convicted or is adjudicated in juvenile court, it's not a conviction. If they're adjudicated, if they offer a plea, at that point they can be expelled. But again, it's up to the principal or the superintendent. So the next one is the one we're talking about, is the one that most parents deal with, probably better than 90%. And that is, they call it all other disciplinary offenses, also known as code of conduct offenses. And these are generally at school or school-related activities like we talked about before, but also potentially, say, cyberbullying is the thing that comes to mind. It doesn't happen on school grounds, but it's impacting the life of children at school. So potentially, if it's a violation of the school's code of conduct, you could be facing suspension for that as well. And the permissible consequences are up to and including suspension at the somewhat discretion of the principal. And the length of suspension can be from 1 to 90 days. But the one thing is there have been rulings that a suspension that happens during this school year will end at the end of this school year. It will not carry over. So if, say, somebody had a 90-day suspension, but school ends at, say, the 45th day, that's the end of the suspension. They're effectively suspended for the rest of the school year. Now, something happened in 2022 that made a major change to this section that we've just been talking about, 34H and 3/4. And that took away some of the discretion of principals. They still have some discretion, but there are a lot tighter parameters on it, like putting bumpers in the bowling alley. You know, it's like there are certain things that you just can't do. Now, it used to be that the previous statute said suspension should be a last resort. It was a very short statute. Just said suspension should be a last resort. They put that in 2012 as a reform because that didn't used to be mentioned. And they started trying to keep track of suspensions, like the state started keeping track. And they realized that that didn't make very much difference at all. And so the new statute went into effect and new regulations went into effect as of November 1st of 2022. And the purpose of this law, as the previous one was, is to ensure that suspension is only used as discipline of last resort. And so I want to talk a little bit about why this is important. Like, why did we do this? Why does it matter? And there's one of the reasons was this came from a report that preceded the law going into effect. The Office for Civil Rights, which is federal oversight, continues to see instances where students with disabilities are receiving discipline because they are not receiving the support, the strategies, the interventions they need to manage their disability-based behavior, or are being disciplined more severely than non-disabled students. That continued to be the case. If you have children or you work in the schools, you may have noticed this pattern yourself. Students with disabilities and students of color are still disciplined at a much higher rate than their white and non-disabled peers for the same infractions. So that's why they were looking at this. And it still continues to be a problem, but if you know how to make the law effective for you, then we can start to make a difference in this regard. So why is it a problem that we're suspending people, you know? First of all, for the individual student, removing them from the classroom, statistically, it's very bad for their education. Their grades drop. This is, on the left side is their grades. Their grades drop, and their chances of dropping out increase. So, you know, every time that a student is suspended from the first time on, it is having some kind of an effect. You've probably heard the term school to prison pipeline. Suspending students is part of that process. And again, disproportionately affects children of color and children with disabilities. And here's the bottom line. Suspension does not work. It does not accomplish anything that we think is a purpose for discipline. I'm sure you know that the word discipline actually means to teach. It doesn't mean to punish, it means to teach. And we need to keep that in mind when we're talking about discipline. And so this was a study that was done a few years ago by the Brookings Institute, which is a think tank, and they put a lot of time and effort into this study, and they found that most principals agreed with that concept, that we should, discipline is to teach children the skills that they need to do well in school. Principals, 88% of the principals do not agree that suspensions and expulsions actually improve behavior. You know, the idea of a suspension or expulsion, suspension in particular, was the child will reflect on what they did wrong. They'll think about why they're not allowed to be in school with their friends, and presumably they'll learn from their behavior. Although there was a caption to this, or a difference to this. Principals in majority Black elementary schools were more likely to believe that suspension was effective than principals in majority white. So that talks about an implicit bias that needs to be, you know, dealt with on a macro and a micro level. 87% of principals did not believe that suspension made the student less likely to misbehave in the future. Again, you know, we think of discipline, if you have this consequence, then the next time that this child is thinking about acting up, they're going to remember they got suspended and not want to do that again. That's the theory. But most principals did not believe that it made that less likely. In fact, if you asked principals, guidance counselors, people who deal with kids who get suspended, it probably makes it more likely that they will do that again in the future, because they discover that suspension is not the end of the world. You know, when we were growing up, oh my goodness, if somebody got suspended, that it was the end of the world. And but kids these days, you know, especially after COVID, you know, oh, I have to do my work at home. You know, it just doesn't have that effect anymore, if it ever did. Most principals don't believe that suspension has a deterrent effect on other students' behavior. Like we just talked about, you know, we would be horrified when we were growing up if a student got suspended. That would be terrible, and you would not want that to happen to you. Most principals don't believe that that is actually true. And most principals don't believe, and this is the most important thing, because we hear this argument a lot. I've been seeing it a lot online lately, you know, that those kids are disrupting my child's education. Those kids should be excluded from school. And the idea being that if they're not in the room, then my kid is going to do better, that the good kids are going to do better. But 81% of the principals, based on their experience, don't believe that that justifies removing the child from, or that it improves the learning environment for their peers. So, but despite that, despite all of that in the study, most principals still used suspension. They answered all of these questions and said, yeah, I can see all these reasons why it doesn't work. And yet, when the questions came down to, do you use suspension, most of them did. And it's a good question to explore. And the authors of the article said, you know, that's a topic for another exploration. But it seemed like the principals felt like they just didn't know what else to do. And this is what we've always done, and so that's why they continue to use it. Now, under the new law, under the new section 34H ¾ those suspension practices that are prohibited are zero tolerance. You've heard we have zero tolerance for fighting in this school. Now, again, remember, this only applies to code of conduct, okay? Yes, we can have zero tolerance for drugs. We can have zero tolerance for weapons in school. We can have zero tolerance for serious assaultive behavior. That's covered under a different statute, that first section that I showed you. But for code of conduct violations, zero tolerance is not an acceptable policy. So if you hear a principal, a vice principal, or somebody else saying, well, we have zero tolerance for that here. No, it's not, that zero tolerance is not tolerated by the law anymore. Inflexible escalating consequences. Some schools have historically had, you know, the first time you don't do your homework, you get detention. If you still don't do your homework, you get Saturday class, or you get 2 detentions. If you don't serve your detention, then you get an in-school suspension. You know, and if you continue with this behavior, eventually you're going to have out-of-school suspension. So it's kind of like a ladder that you climb, and you know what's coming next. That is not allowed under the new law. So the principal can't say, well, we gave him 3 detentions and he didn't show up for any of them, so now we're suspending, because that's our policy. It's not allowed anymore. And also unfettered principal discretion. There's still discretion to a certain extent, but there are guidelines. So the law requires certain things to happen before you suspend a student. And it says, I'm taking language from the statute. The principal shall consider ways to re-engage the student in the learning. That means step back from what's going on and think about what's going on with this student and how can we get them re-engaged in learning. The principal shall not suspend or expel a student until alternative remedies have been employed, actually used, not just considered, but actually used, and their use and results documented. And the important thing is, oops. Okay, I thought I had put it on here. For each infraction, so again, it can't be, oh, we tried that before, okay? Each time it has to be looked at as an individual incident. I mean, you can certainly look at the pattern. You're considering the child as a whole. But again, it's to prevent that, oh, we tried this and we tried that, and we've given up on this student now, so we're suspending him. And I'm being very flippant about that. I don't want to be dismissive of the issues that behavior problems cause in schools, but I'm just explaining the point of view of the statute. So the statute outlined 4 recommended alternatives, but also said these are not inclusive. You can try other things too. So mediation might be something that you try if it's a conflict between students. Conflict resolution. Restorative justice. So for instance, if a student, say, had a meltdown, and in the course of that meltdown, like they tore down a bulletin board that a teacher had, put a lot of hard work into, okay? So the restorative justice might be that the student helps the teacher to put that bulletin board back together again. The student learns something from that. They learn, for one thing, how much work it was for that teacher to put that together and what the purpose of that bulletin board was, like what lesson, for instance, it related to, or what kind of qualities it was trying to encourage in the classroom. And it also provides the opportunity for engagement with the teacher, for the teacher and the student to get to know each other better, for the student to appreciate the work that the teacher put in, and for them to to create a relationship. And relationship is what keeps kids in school. Relationship is what makes kids want to behave better. They want to do better. And as is often said, kids do well when they can. And so we have to remember that as well. So, oops, I went the wrong way. And then collaborative problem solving is another one. And as part of the passage of this legislation and the regulations that came along with it, the Department of Elementary and Secondary Education was ordered to put together trainings and materials for schools to learn how to do these things, because these were not typically things that schools were expected to be able to do. So now there are procedural requirements, and this is where parents can be empowered. The first thing is that there has to be a notice to the student and the parent. Typically, you'll get the phone call, the dreaded phone call from the school. And so that's an opportunity for the parent to say, well, what happened? And what were the circumstances? And what are you thinking about doing? And even asking the person who's contacting what alternatives, if they say suspension right off the bat, which is probably what's going to happen, for the parent to say, what alternative remedies have you tried? And it may well be that they haven't tried any because they haven't thought of it, okay? So it gives the parent a chance to say, okay, what alternative remedies have you tried? And then there's written notice required. And the written notice has to contain the charges and the reasons for the proposed suspension, okay? But this is the most important one. Opportunity to be heard before any suspension takes place. Now, this is typically not happening in the cases that I'm called on. If things are happening right, people don't usually call me. But when I get calls from parents saying, my child has been suspended and there's a hearing tomorrow morning, that child is typically the school will call and say, you have to come get him, he's suspended. No, the statute says he's being considered for suspension. He's not suspended until there's a hearing and an opportunity to be heard. And at that hearing, the parent has to be given an opportunity to attend and participate in the meeting. And so that, again, is the parent's opportunity to say, I would like you to consider, for instance, conflict resolution, and especially because the meeting usually happens like the following day or a couple days later. You will have had a chance to talk with the child, find out what was happening with the child at the time that this incident occurred. This is not a good time to sit there and say, my child didn't do anything. That's not what I'm advocating for at all. This is the parent's opportunity to look at alternatives to suspension and propose those to the school. whatever that might be. And parents know their kids the best. They know what will work with their kid usually. And so you might suggest something that the school would not think of. The principal has to demonstrate reasonable efforts to include the parent or guardian in the meeting. So they can't just say, well, the parent didn't show up, you know. And part of that reasonable efforts is that notice has to be sent. Both the verbal notice and the written notice have to be sent in the language of the family. So that's another important thing. And then, if you have the hearing and the principal still decides that the student is going to be suspended, they have to write a new notice to the student and parent reflecting the decision to suspend. It has to be in writing. It has to reflect that you had this meeting and what was discussed. And it has to document the alternative remedies that the statutes that have to be employed and the results. So that should all be in there. This should not be a form letter. This is something that's supposed to be reflective of the actual experience of the student. Or the alternative that the statute gives the principal is you have to document specific reasons as to why those alternative remedies are unsuitable or counterproductive, or there is a specific documentable concern about the infliction of serious bodily injury or other serious harm upon a person. And it has to be, for instance, I was recently called in on a case, and the principal had written, it was a form letter. The principal had written that there are specific reasons why alternative remedies were unsuitable, or specific documentable concern. And the principal had written that, in this section, had written that it was disruptive to the school, that the student's behavior was disruptive to the school. This student has some mental health issues, and got very, what's the word? For lack of a better term, I'm going to say the student dissociated and got up and left the classroom and was kind of wandering around the school. And they could see on the video where she was. She wasn't doing anything. She wasn't making any noise. She wasn't harming anybody. She was wandering around the school. They sent a guidance counselor to try to talk to her. She was unresponsive. They were calling that defiant. She was unresponsive because of the mental state she was in. And so basically I wrote back to the principal. They had scheduled a meeting, but they had already suspended her, had her caregivers come and take her out of school. And I wrote back and I said, this, and they had called it a 2-day emergency suspension, which the law does allow them for certain circumstances like this, for the safety of the school, to allow them to remove a student in very extreme circumstances. But I wrote to the principal and said, you can't suspend her for this. She doesn't meet either of these criteria. No defiance by itself is, just not listening to a teacher, not being redirected does not fall under this. And so then we went into the meeting the next morning and I was expecting a fight. And when I got there, they were not talking about suspension at all anymore. They were talking about how can we help her. So it is something that, you can convince a principal of. And then if the student is suspended, the parents also have a right of appeal if the student has been suspended for 10 days or more. Basically what you do is you appeal to the superintendent in writing within 5 calendar days of the effective date of the suspension. And they have to give you a hearing within 3 school days of the request for appeal. And then the superintendent has to issue a written decision within 5 calendar days of the hearing. And there is, I've made an asterisk on a couple of the timelines there. The parent can request up to a 7 calendar day extension. The parent has that option, not the school. But if you, for instance, you're working on your appeal and you don't think you're going to be able to get it in on time, or you want to consult an attorney, you can notify the district that you're asking for up to a 7 calendar day. This typically happens, like if somebody contacts me and says, I want to hire you to file an appeal, and if my workload doesn't permit it within 5 days, but I can do it within 7, I'll say, ask the school, tell the school that you need an extension until 7 days from now. And again, the same with the hearing request. The school has to give you that hearing within 3 days. A parent can ask for an exception. And that might be to have an attorney present. It might be to have an advocate present, or to, for instance, be able to schedule with the child psychologist or somebody else that you want to have present. So this is just a quick look at the timeline. If the student is suspended on, say, that Monday, the appeal deadline actually happens to fall on a Saturday, but it says calendar days, so it's going to land on that Saturday, and the school will get it the following Monday. I mean, the school won't act on it until that following Monday. But then the school has to have the hearing within 3 calendar days, so they would have to have it by that Wednesday. And then the principal has, the superintendent has 5 calendar days to get issue their decision. Okay, so now the student's rights at such a hearing they're very important. This is part of the due process under the 14th Amendment. They have the right to present oral and written testimony. So this is kind of like the practical. Okay, so I have these rights, how do I do this? Okay, and how you do this is you find your favorable witnesses. If this was like an incident that happened at school, it might be other students, it might be staff, it might be a teacher or a guidance counselor. It might be an outside service provider. It might be the child's BCBA if this was a case where the child acted out because of some effect from autism. So it might be the BCBA, it might be the child psychologist. You have the right to present documents as well, and also written testimony. You would have the right of presenting statements from witnesses as opposed to having them come in and testify. That's permitted. This is not a court. So hearsay isn't an issue. You can put in those documents. Video, there is typically video. The school probably has it. A lot of times they'll give you a hard time, but I guarantee you there will be video if it happened in the school. I've had that situation where I've asked to see the video of an incident and the school goes, oh, we can't show you that. We can't show you that because there are other students in the video and that would violate their privacy. And I'm like, every student, if you saw the video, every student would be doing this, videotaping, and then they posted it on their Snapchat that night. So it's like, there is no student privacy. It's all over town. Everybody knows what happened. You find the video and you present it. You also have the right to cross-examine witnesses. So, typically that's going to be some school employee. So what you want to do to be able to cross-examine a witness is to obtain all the reports. Usually, the letter that you get from the school, from the principal, suspending the child is not, I promise you, the only documentation that there is. Excuse me. Witnesses probably will have written statements. If the principal conducted an investigation, there are notes from that. Depending on the circumstances, it may be something where there's a state mandated form that had to be filled out. If they made a complaint to the police, you're entitled to find out, did they call the police? If they called the police, you can go to the police department and get a copy of that report. And this is one of those reasons why you might ask for an extension, because you want time to prepare your case. 3 days is not a lot of time to prepare a case. So you can get all of those reports, but here's the practical matter. If you want to cross-examine the school's witnesses, particularly if it's someone that the principal relied on in making their decision to suspend, you do want to cross-examine that person. You need to request the presence of that witness to be able to cross-examine them. And that's a real practical thing that isn't written into any law. It's like you have the right to do that, but how do you do that? You would say to the superintendent, I want these witnesses who are school employees to be present because I have some questions for them. And then the school should provide that. You also have the right to counsel. It's one of the few times it's written right into our statute that you have the right to counsel. And then, if the superintendent upholds that suspension, and this applies to all students, not just students with disabilities, if you're suspended for less than 10 consecutive days, you still are entitled the opportunity to make academic progress. So typically what that means is that somebody at the school will be responsible for collecting your assignments, or nowadays, depending on what grade you're dealing with, all the assignments might be on their Chromebook. They can still do the assignments and earn the credits that they've missed. If they're suspended for more than 10 consecutive days, that opportunity to make academic progress has, in addition to making up the assignments, the school needs to come up with some kind of an education service plan, because a kid who's missing more than 10 days of school needs more support than just being able to do their assignments online. And the school still has the obligation of providing an education to these students. So an education service plan, the things that are specifically in the statute are either tutoring or an alternative placement. There are schools or organizations out there that will provide an alternative placement, Saturday school, or online or distance learning. Those are all opportunities that are available, and this is all at no cost to the student, or to the parent rather. So the biggest difference between the rights that every student has under the Massachusetts law and what students who have special needs comes with a manifestation determination under the Individuals with Disabilities Education Act. And so, first of all, what does that mean? What is a manifestation determination? It sounds really heavy. It's a mandated process. It's required by the federal law. The team considers all the relevant evidence to determine whether the conduct for which the child was disciplined is either caused by the child's disability or had a direct and substantial relationship. But usually you can say it was caused by the disability. A child with autism had a meltdown and did something that violated the school code of conduct. Well, it was the disability that caused that. Or the direct result of the district's failure to implement the IEP. And a really easy example of this is the child is supposed to have a one-to-one paraprofessional or aide. And usually the child has a paraprofessional or aide. And that day, the paraprofessional or the aide is out sick, and the school does not provide a substitute. So the child who is used to having this support doesn't have this support for that day and loses it. So that's a real easy example. So you can't suspend the student for that. It's not his fault that's the bottom line. A manifestation determination is to figure out whether the student is actually at fault or if this was something that the student had no control over, or that the school, had this happen because they weren't doing what they were supposed to do. So who's eligible? Basically, any student who's receiving educational services under the IDEA. That means you need an IEP. You are not protected by a 504. And that's why when schools say, oh, we don't think he needs an IEP, but he can have a 504. Well, that's all well and good, but that student with a 504 is not protected, is not entitled to a manifestation determination. So that's another reason to push for the IEP, especially if your child has autism or some kind of mental health issue that may cause that. Mental health issue is a basis under the IDEA for an IEP. It is one of the 13 enumerated conditions. A regular education student may be able to show that the district, even if they're not, this is a regular education student, not on an IEP, but the district knew or should have known that this child had a disability. And there are a few ways that there are 3 ways that the statute defines knowledge. One is if the parent expresses concern in writing about the child. And this is, if you were at our last one, that was one of the big things at the Basic Rights Workshop that I told everyone is, if it's not in writing, it didn't happen. If you have a concern, don't just talk to the teacher, don't just chat with the guidance counselor and then say, well, I told them, because there's no proof. So do that, express your concerns in writing, okay? Email counts as writing, and keep a record of it. If the parent requests an evaluation, that's immediately letting the school know. Or a teacher or other school personnel expressing concern directly to the special education director. That doesn't happen very often, I don't think, but that is one of the, and it's not just, notice, it's not the teacher saying to the parent, I'm concerned about your child. The teacher has to go to a particular person and say, I think that this child needs to be evaluated. Now, so that's who. Now, and here's the situations under which that child is eligible. If they've been suspended for more than 10 days, or 10 or more days in a school year, that does not have to be consecutive. So this is different from the other statute we just looked at, okay? It's more than 10 days in a school year. And that can happen quickly. Because, and we'll talk about informal suspension in a little bit, but those days here and there can add up quickly. Suspension for, the reason that they have that number is suspension for 10 or more days is considered a change in placement under the IDEA, and that can't be made unilaterally by the district. The team, the child's team, has to make that determination. So the manifestation determination, that's essentially a team meeting. The district is not required to provide the special education services during those initial 10 days, okay? They still have to provide an opportunity and all the stuff under the statute, opportunity to make academic progress and make up their work and everything. But the school is not required to provide the services that a child would get under their IEP during those 10 days. Now, this is another one of these practical nuts and bolts. Who goes to a manifestation meeting? Typically, when that manifestation determination meeting is called, the principal calls it, or the whoever does the coordinating in your district for any team meeting, and they'll invite you to the meeting. And you may see the names, you should see the names of the people who are being invited. But this is the thing. This does not have to be like the same team that developed the IEP. The parent or guardian obviously can be present, has a right to be present. the district representative, and typically this will be the principal because this is a suspension issue, where most principals do not attend every IEP meeting. Typically you will have the principal there. And then it says relevant members of the IEP team as determined by the parents and the district. The parents have the right to have input as to who is going to be in this meeting. So, so if there's someone in particular, if you want the child's if you want the child's guidance counselor there, you need to let the ETL know, or the person who's coordinating the meeting. Just tell them anybody that you want there, a particular teacher. Relevant is composed of persons who are familiar with the student's profile and their IEP. And there actually are cases, and I think I cited one here. Nope, I didn't. But there actually are cases through the Bureau of Special Education Appeals where they have thrown out determinations by the team. Typically the manifestation determination will come back and say, well, no, it wasn't a manifestation. And then the parent, that's the final right of the parent, is if the manifestation determination says, no, this was not a manifestation and the child is suspended, the parents can go to the BSEA. And I found at least a couple of cases that said, in instances where the people who were there, who were designated by the school, the parent didn't know the parent actually testified she did not know that she could ask for certain people to be there. The school determined who was coming. And most of the people that were on the team really did not know the child well. Something that had happened at the beginning of the school year. So the gen ed teacher had worked with the kid for like 8 or 9 days. The special ed teacher had worked with the kid for like 3 days. And then there was a psychologist who had done an evaluation 2 years ago. So this, the BSEA basically threw out the suspension. But this is, again, after a long period of time. The child's been out of class. The parents have spent a lot of money, unless they're trying to do it by themselves, which does not work out very well most of the time for the BSEA. So, it's at great cost to the child and the family if you go that far. So just know that you can bring people to the meeting and insist on people who are familiar with the student's profile and the IEP. And then what the team does is they review all of the relevant information, not just, it's very different from that other suspension hearing under the Massachusetts statute where you're basically just considering the circumstances of the event that led to the suspension. Here, we're looking at the child's IEP, we're looking again at all of the evaluations. That means, it doesn't mean you have to go through all the evaluations again, but for instance, as a parent, you want to go through those evaluations and find those things in the evaluation that may support what you're saying. If an evaluation said the student really should have this kind of support and that's not in the IEP, then that can be very relevant in the determination. Teacher and staff observations and any relevant information provided by the parents. That can include, for instance, information from an outside counselor, from a pediatrician. I've had a few cases where the child was just changing medication and so wasn't fully transitioned to new medication. Those kinds of information can be really helpful. So this is, again, this is not just a routine thing where you go in, you sit down, and then somebody hands down a decision. This has to be a team decision, and you really have to prepare for it. Prepare for it like you're going to court. Get all of your ducks in a row. And then the team has to determine whether the conduct meets the criteria. Again, either caused by or had a direct and substantial relationship to the child's disability, or the direct result of the district's failure to implement the IEP. I just thought of one example where it wasn't so obvious as this is a child who had autism. He didn't have a meltdown at school. He got caught with drugs at school, with a marijuana vape cart, whatever the kids call it these days. He got caught with it. And so that would seem to be like cut and dry. He's got drugs on campus. He's being suspended. This kid had autism, but he was high functioning. And so they kind of treated it, he also had ADHD. So kind of the school was mainly treating him as a student with ADHD and not so much autism. He was of average cognitive ability and so forth. But because he had autism, he didn't have a lot of friends. And this kid who was about to be searched for drugs because they thought that the other kid had drugs, had given this and said, "Hey, buddy, can you hold this for me?" And so, the mother's like, "What? Do you know this kid? And I said, was this kid a friend of yours? And he said, "Well, he is now." Okay. Kids with autism are very prone to being manipulated by others. I also saw this when I was a prosecutor, that people with developmental disabilities or autism or things along that line, when they're high enough functioning that they recognize that they don't have friends like other people do, that they don't have the relationships that other people do, but they want that. They are very prone to being manipulated into doing things such as carrying drugs for somebody, or, bring this contraband, or, "Oh, quick, carry this gun for me," that kind of thing. So it's a real thing. So that would be, you wouldn't necessarily say the autism caused him to carry drugs, but his autism created the situation where he was open to doing that, even though he knows he shouldn't have drugs. But he wanted to be friends with this guy, and this guy acted like his friend, and he is now. So that's another example. And that's why I say you have to really look at the evaluations and look at what that disability makes a child vulnerable to. So if the conduct is determined to be a manifestation, then the student can't be suspended. So there's that little nugget of truth in that myth. If it's a manifestation of his disability, the student cannot be suspended. Child has to return to the original placement unless the parent and district agree otherwise. And that might be part of what comes out of the manifestation determination, is that this is not the right setting for this kid. And so we need to have some place where there's more support, or typically more support. The school is supposed to conduct a functional behavioral analysis, which, big words, it basically means that a BCBA or a school psychologist who is trained in doing an FBA is trying to figure out what was the motivation for this behavior. And typically it's to avoid something that they find unpleasant, or to gain something that they find pleasant. So they're like, what is the motivation there? And then once that is figured out, then you have another team meeting and come up with a behavior plan to support the child in that way. So, or you may decide that the FBA may come to the conclusion that there is not, this was an isolated incident, there's not a need for a behavior plan. If the conduct is determined not to be a manifestation, the student can be disciplined in the same way as any other student. The school has to continue to provide the appropriate services under the IEP. And this is where the parent can request an expedited hearing. Even an expedited hearing takes quite a long time, but if they disagree, they can ask for an expedited hearing. And when they do that, they can invoke stay put, meaning that the child stays where they are, pending the appeal, except in the cases of drugs, weapons, and dangerous behavior. So, which I think we all understand. Whoops. Okay. Yeah, all right. Wow.